and knowingly subverting the Constitution of the United States of America, and that will not stand with this body, sir.
We have a Second Amendment because we understand in this country that there are some things, inalienable rights.
The Second Amendment, of course, is an important part of our Constitution.
What we're doing is we are subverting the Second Amendment.
New York restrictions. The enforcement of new limits on the carrying of arms on privately owned, publicly accessible land was halted by a U.S. appeals court ruling, which upheld New York State's right to prohibit arm owners from carrying weapons in sensitive locations, such as parks, zoos, bars, and theaters. Since the U.S. Supreme Court's historic decision last year expanding arm rights, the Second U.S. Circuit Court of Appeals judgment represents the first time a federal appeals court has made a determination about the locations where lawfully licensed arm owners can carry arms. The three-judge panel's decision, according to Democratic New York Attorney General Letitia James, would let the state keep enforcing most of the new arm control laws' provisions. My office will continue to defend New York's arm laws and use every tool to protect New Yorkers from senseless arm violence, she stated in a press release. Arm rights organizations applauded other aspects of the court's decision, which concluded that other portions of the law, such as a clause making it illegal to carry an arm on privately owned property that is accessible to the public without the owner's express consent, were probably unconstitutional. The court further declared that it was probably illegal for the state to forbid the carrying of arms in houses of worship and stop the implementation of a law requiring applicants for concealed carry permits to reveal their social media accounts.
It is very easy to legislate the removal of an inanimate object. I've been carrying weapons.
Tyrants disarm the people they intend to oppress. Those are the facts.
The Second Amendment, of course, is an important part of our Constitution.
The 261-page decision is the result of court challenges to the Concealed Carry Improvement Act, which Democratic Governor Kathy Hochul signed into law in July 2022, filed by arm rights organizations and New Yorkers. The legislation was passed in response to the Supreme Court's decision in June to overturn New York's stringent arm laws and to establish for the first time that a person's right to carry an arm in public for self-defense is protected by the Second Amendment of the U.S. Constitution. New York State Rifle and Pistol Association versus Bruin established a new standard for determining whether arm laws are constitutional, stating that they must be consistent with the nation's historical tradition of arm regulation. The scope of who might apply for a license to carry a weapon outside the house was increased by a new law in New York, but candidates had to prove they had good moral character. It also established a lengthy list of sensitive locations where carrying an arm would be illegal, even for license holders. These locations included theaters, public parks, medical facilities, and churches. One of these places is the well-known Times Square in New York City. Following lawsuits by a number of arm owners in New York and advocacy organizations including the Arms Policy Coalition and Second Amendment Foundation, a lower court judge ruled that a large portion of the bill was illegal because it conflicted with the country's historical laws. However, a three-judge bench overturned previous rulings in relation to most of the limitations, finding that many of the clauses were in line with the nation's long-standing tradition of banning arms in public places and congested regions. Law under scrutiny. The Second Circuit Court of Appeals has recently expedited hearings in 5 cases challenging New York's new concealed carry law, the Concealed Carry Improvement Act. This law, considered hyper-restrictive, was swiftly enacted just 8 days after the Supreme Court's landmark decision in the New York State Rifle and Pistol Association versus Bruin. The CCIA, however, seems to disregard the Supreme Court's ruling in Bruin, prompting a renewed focus on concealed carry and the broader implications for the Second Amendment. The Supreme Court's decision in the Bruin case invalidated New York's previous concealed carry legislation. Despite this ruling, New York persisted in defiance, leading to legal challenges in the Second Circuit. Arm Owners of America has urged the Supreme Court to re-review the concealed carry issue, emphasizing New York's continued defiance of the Second Amendment. GOA seeks a renewed Supreme Court intervention to strike down New York's noncompliance. In the Bruin decision, the Supreme Court emphasized that government restrictions must be rooted in the history and tradition of the nation, dating back to 1791. However, New York responded by enacting the CCIA, creating a permanent scheme even more restrictive than the one overturned by Bruin. Numerous legal challenges were filed against the CCIA, resulting in preliminary injunctions from federal district courts. However, New York appealed these decisions to the Second Circuit, which granted blanket stays without issuing detailed opinions or holding hearings. Responding to the Nanook case, Arm Owners of America sought emergency review from the Supreme Court, which denied the relief but emphasized that the Second Circuit couldn't ignore the matter. The Supreme Court gave the Second Circuit the option to either expedite hearings on the CCIA challenges or provide an explanation for denying the stays. The Second Circuit opted for expedited reviews in all cases. This development, while not granting immediate relief to arms rights advocates, highlights the ongoing legal battles over concealed carry laws and the defiance of New York against the Supreme Court's Bruin decision. The expedited hearings signal a continued legal tussle with potential implications for concealed carry rights and Second Amendment jurisprudence. Review of CCIA challenges. The Supreme Court might consider reviewing GOA emergency pleas following expedited hearings in the Second Circuit, where 5 rulings were rendered on various cases challenging New York's CCIA. The Gazzola-Vacco case also tackles the effects of CCIA on arms-related financing limitations and certain ammunition restrictions. Despite prior discussions on these cases, the Second Circuit's decisions, which distinguished Bruin as an exceptional case in its December ruling, resulted in vacating some district court injunctions against CCIA enforcement. This decision asserted the constitutionality of CCIA under the Second Amendment, even in the wake of the Bruin decision, which prompted arguments against the necessity of Supreme Court review.
And knowingly subverting the Constitution of the United States of America, and that will not stand with this body, sir.
Joseph Story, in his commentaries on the Constitution in 1833, quote, "The right of the citizens to keep and bear arms."
Are you calling for the repeal of the Second Amendment?
I am not.
Critics find the Second Circuit's position almost absurd, emphasizing that Bruin and its rationale should be distinguishable from the CCIA issue. The Second Circuit's ruling asserted the constitutionality of CCIA despite Bruin's influence. In response to this, Arm Owners of America has filed a petition for Supreme Court review, highlighting the emergence of numerous opinions post-Bruin regarding the historical justifications for governmental restrictions like those found in CCIA. The petition seeks Supreme Court intervention to address the constitutional implications of CCIA and potentially overturn the Second Circuit's decision. The legal battle over concealed carry laws in New York remains complex, with the potential for significant implications on Second Amendment rights. Battle over historical support. Arm Owners of America contends that certain courts, like the Second Circuit, inappropriately permit later historical support in Second Amendment cases. In their petition, GOA emphasizes the need for a definitive answer to the question of historical timelines, specifically addressing the debate between 1791 and 1868. Despite nearly 2 years passing since the Bruin decision, lower courts have failed to coalesce around a clear resolution regarding the historical context of the Second Amendment. The petition highlights a multi-way circuit split on the 1791 versus 1868 question, with district courts displaying disarray in their approaches. The petition argues that the Antio case in particular serves as an excellent opportunity for the Supreme Court to resolve the ongoing debate. GOA asserts that the lower courts, especially the Second Circuit, have disproportionately relied on historical laws enacted well after the Second Amendment's ratification. This includes laws from the mid to late 19th century, with some enacted nearly half a century after the nation's founding. The Second Circuit's singular focus on later historical support becomes a significant factor in the outcome of the Antio case and potentially influences other Second Amendment challenges.
The Constitution of the United States has a provision that's written into it that allows you to change the Constitution if you feel
Reasonable to conclude that gun confiscations facilitated by laws requiring the registration and licensing of firearms.
Gun control is not an area that the Civil Rights Division, under any administration, has.
The petition sheds light on the tactic employed by some liberal courts and anti-arm advocates who justify arm restrictions using historical precedents, often relying on later arm control laws and, in some cases, discriminatory legislation. For Californians facing concealed carry restrictions under SB 2, the outcome of the Antio case holds crucial implications. The resolution of this legal battle could impact not only Antio, but also set precedents for future Second Amendment challenges involving historical support. Implications beyond New York. California responded to the Bruen decision with a similar carry ban, echoing the rationale and language used in New York. The California Rifle and Pistol Association filed a lawsuit against SB 2, challenging the ban. The case is currently under consideration in the Ninth Circuit, where debates on historical evidence are anticipated. The Antio case, recently reviewed by the Second Circuit, will likely play a significant role in shaping arguments in the Ninth Circuit, impacting not only New York but also California.
We have a Second Amendment because we understand in this country that there are some things, inalienable rights.
what we're doing is we are subverting the Second Amendment.
Why do we have guns? Why do we have the Second Amendment?
The ongoing debate over historical support, specifically the timeline between 1791 and 1868, is not a genuine discussion, but a strategic move by anti-arm advocates. Recognizing the lack of support for their modern restrictions in historical evidence dating back to 1791, they attempt to shift the historical goalpost by relying on later evidence. Gun Owners of America concludes in their petition that the Second Circuit, along with other lower courts, consistently contradicts the court's rulings in Bruen v. States. The panel in the Second Circuit deemed Bruen an exceptional case, asserting that they were not obliged to apply its methodology in cases involving less exceptional regulations. This defiance by lower courts, including the Second Circuit, prompts GOA to seek Supreme Court intervention once again. The GOA's appeal to the Supreme Court aims to address the concealed carry issue directly and confront the defiance stemming from the Bruen decision. If the Supreme Court agrees to review the case, the implications will extend far beyond New York, impacting states like California and their concealed carry bans, along with various other legal challenges. This development will be closely monitored for its potential to shape the future landscape of Second Amendment jurisprudence. That's all for this video, folks. We'll see you next time.